Hi, ladies. We are here again, Lexi and I doing our Cherry Hill Squares. And we are here today with Erin Brignola. She is one of our attorneys with our bankruptcy practice. And we are looking to discuss the impact of bankruptcy when we're talking about the context of divorce proceedings. Lexi, how are you doing?
I'm good. How are you? And how
Good.
are you, Erin? It's good to see you.
Good to see you all. It's nice to be part of this.
A little fun fact for our audience is that we tried to record this before and Cynthia sounded like a robot. So this is our second attempt. As we all know, finances and divorce go hand in hand. They're inextricably linked. And bankruptcy also as well, because we have clients that are in some difficult financial situations. That's just life, right? So what I want to know, and is something that actually happened to me, and so I kind of wanted to talk about it for our viewers, is what happens when a client is going through a divorce proceeding and then in the middle of a divorce proceeding, they file for bankruptcy. What effect, if any, does that have on the divorce proceeding?
Well, that's a very good question. As you're aware, your family law action is a state court action, but the bankruptcy court action is a federal action. And so the federal action will trump the state court action, and immediately everything will stop because of something known as the automatic stay, which is a protection umbrella for bankruptcy debtors that relieves them from other kinds of lawsuits or takings, such as their cars repossessed or something like that. So immediately everything will stop, but the code has changed, and since 2005, they have made special provisions for family court matters. And so any kind of proceeding for just a simple divorce, not property or debt division, child support, alimony, spousal support, protection from abuse, any of those things are not stopped by a bankruptcy action. You will have to inform your family court judge that there has been a filing, so that everyone is made aware, because if there's any kind of order made, you want to make sure that the bankruptcy court has certified that and it's not ending up to be a void order. But the only thing that is in essence really stopped would be the property and debt division matters.
Yeah, I had a tough situation where literally between the first trial date and the second trial date, the defendant filed for bankruptcy. So it caused quite a commotion in our case. But that's just a reality of these cases, where if somebody does that during a divorce, then certain issues can unfortunately grind to a halt.
Yeah, and sometimes, unfortunately, it's used as a tool in family court. You know how diverse the parties can be on polar opposites. And so if they decide that it'd be more advantageous for them, sometimes they'll file a bankruptcy just to make it difficult to get back on the court's calendar, because it takes forever to schedule these things. So it can be a tool, and that's an unfortunate circumstance for the party that did not file.
You said a mouthful there. I mean, this is why so many of our colleagues say, how could you ever do family law?
Yeah, and in these circumstances, I've certainly had experience with a client choosing to file a bankruptcy during the pendency of her divorce, when all of the debt that was accumulated by the husband during the marriage was in her name. And so she wanted to try to realign those facts and have that debt and those claims that were being levied against her revisited in the bankruptcy court before they were subject to division in the family court matter. So, and that brings me to my question, Erin. When we're dealing with clients and consulting with clients, strategy-wise, what is your advice on when they have a substantial amount of debt and they are potentially contemplating a divorce? Which action do you suggest that people pursue first?
Well, it is circumstantial. And if you have parties that are willing to enter into some kind of agreement of matters, then the best way to go about it, hopefully, is to, while they're married, file a bankruptcy petition together before they file the divorce, because you cannot file a joint bankruptcy petition if you're divorced. You have to still be married, just like filing a joint tax return. And so if they do that, then they can eliminate all of their debt. And then they just have a very simple divorce process, or they deal with child issues, that kind of thing. And they don't have to worry about being stuck with the debt. For instance, if one, as you said in your original statement, she decided that all the debt was really in her name with her creditors, but it was, she believed to be really the husband's responsibility for the debt, and maybe he didn't have it in his name because he didn't have any credit. Now they're getting divorced and she's thinking, now I'm still going to be stuck with his debt. What am I going to do? If she files a bankruptcy at that point, she does get rid of it with regards to the creditors that she owes, the bank, the credit card companies, those people, and she gets a discharge of that debt. But if family court turns around and says, well, even though it was all in your name, and even though you filed a bankruptcy case, he cannot afford to take on this debt if they come after him for some reason, if it's some kind of joint obligation. So therefore, if he gets stuck paying it, you're still going to have to pay to him whatever he's stuck paying and indemnify him. So it can be a very difficult process. The best thing to do, if you cannot agree, is to consult with a bankruptcy attorney before you do anything, because in your situation, it might be better to instead file a Chapter 13, which gives you a super discharge. And a lot of times it will just take away any kind of debt component, and you will actually be discharged of the debt. But a Chapter 7 won't do that anymore.
Certainly. And in that case, it was judgments related to a business, and they did utilize a Chapter 13 to protect my client and thus the estate. And in the end, the sticking point was alleged loans taken from the husband's parents that were also discharged under that filing. So the question in the family court came up as to whether the wife should have to be responsible to the husband's parents, even though those debts were discharged. So it was an interesting mix.
Never a dull moment.
Yeah, and I actually have a follow-up question to that, Erin. What happens? So in my mind, the filing of the complaint for divorce creates the end of the marriage, right? In our litigation, that's the signifying date for an end of a marriage. Right. So can parties file a joint bankruptcy after the filing of a complaint for divorce, but before a final judgment of divorce is entered? Or does it require a withdrawal of that complaint or something else? How does the bankruptcy court treat a joint filing if a complaint has been filed but not fully prosecuted yet?
Well, in your situation, first of all, the filing of the divorce petition creates the injunction. So you first have that. So it's stopping both parties from doing anything except if they're going to communicate with each other and do it together. So then if they decide, okay, maybe we should have filed a bankruptcy petition, they can do that because there is no divorce decree, which is the finality, which says that they are no longer allowed to claim themselves as a married couple. So they certainly can do the filing of the bankruptcy after the divorce petition is filed. And what they need to do is maybe not ask for the divorce hearing or continue to adjourn the divorce proceedings until they can get that bankruptcy petition filed and the discharge entered. Once the discharge entered, then there is no more automatic stay and they are free to proceed with asking for their divorce decree.
Understood.
Just like taxes, where
Right.
if you're married, it doesn't matter if you file for divorce, if you're still legally married, you haven't been granted a divorce, you can file jointly.
Yep.
Well, thank you, Erin, so much. And we like to end on a fun question just to lighten things up a little bit, because these are some heavy topics sometimes. So Our fun question today, which is usually asked by our darling Lisa, who's out on maternity leave, is, and Erin, you go first. What do you like to do? What's your favorite thing to do in the snow?
Well, my favorite thing to do in the snow is funny because we're here at our house, we're not very good at building snowmen and rolling the balls. So we create snow blobs. And that's the fun thing that we like to do instead of snowmen.
And unlike Lexi, I do not have an aversion to the snow. So personally, I enjoy the snow, and my favorite thing to do in the snow is to go snowboarding. So I haven't done that yet this winter, despite our awesome winter and the great amount of snow where I am. But that is my favorite thing to do in the snow. So for right now, I limit my activities in the snow to walking my dog and playing with him in the snow. But snowboarding is it for me.
Well, Cynthia sort of telegraphed my answer, but I don't like the snow at all. I don't like the way it looks. I don't like when it hangs around and gets dirty. I don't like how inconvenient it is. So my favorite thing to do with snow is watch it melt and have spring come. I don't like snow. I'm a Scrooge, and that's the end of that.
Well,
That's all she wrote.
Perfect. So we can end on that note. Thank you both.
thank you for having me. I'd love to come back sometime.
Perfect.
We would
Great.
love to have you.
All right.
Thanks,
Bye,
guys.
ladies.
Have a great day.
You too.